Good morning, folks. It's Andy Stautz at Stautz Law. We're back for another quick talk about Indiana probate administration. Today's topic is creditor notices. What do we mean when we talk about creditor notices? Well, creditors are people who, hold debts owed to them by the estate. So this can be real things like, a car loan, a big formal thing that you'd think of as a debt. It can also include little things like an unpaid last utility bill, right? It's not like something that the decedent signed on for a loan, but it's the power and light company or whatever provided them with a service, expectation of getting paid later. It counts as a debt, so they're a creditor potentially. Okay, so creditors are everybody who might have these debt claims against the estate. Notices are how you tell the creditors about the fact that the estate exists. And this is important because in probate administration, there's a very set way to administer these claims, basically to gather them all and figure out which ones are valid and pay the ones that are valid and get rid of the ones that aren't. Because the point of probate administration is to settle everything, right? We don't want creditors of someone who's died coming back years later or pursuing the heirs, or, we got to get it done now. So there are time limits for when creditors can file their claims. We either have talked about that or will talk about that. There are time limits for when claims can be filed. There are ways to evaluate, whether they're valid or not. There's an order of priority for, if there's not enough money to go around, who gets paid first. But the creditors need notice so that they can participate in that process. So creditor notice is required in two different ways. One, you publish the notice of estate administration in every case, right? The probate code says when letters are issued, you publish notice. So in the newspaper, there's this whole section, we're administering the estate of so-and-so. No ordinary person reads that, but creditors read that. And so that's one way they could find out about the estate administration in time to make their claim. The other way is the personal representative, or usually it's me, the personal representative attorney, mails a specific notice. It's the same words, but mails a notice to known creditors or reasonably ascertainable creditors. So who's that? Well, if you get bills in the mail, right? If you look in their emails and you see correspondence with a loan officer, you sort of figure out who that might be, and then you've got a duty to tell them specifically. So you publish to the whole world, and then you say, oh, and by the way, we're pretty sure, these people could have claims. So they get mailed a notice. And then either the personal representative or the attorney has to certify to the court, yes, court, we mailed notice to these people. Okay, and sometimes that's none. Sometimes that's just the unit, Medicaid estate recovery, which we talked about last time. And sometimes that's a whole list. And sending the notice doesn't commit you to anything. It doesn't promise that the claims are valid or that these are actually creditors. It's just kind of, here are the people we think might be involved. Because the idea is for it to be fair, right? You don't want to sneak away with this. The point of probate is it's all above board. We get all the claims out in the open, right? We pay the right ones and we're done. So creditor notice is kind of what starts that. So that's the process. I hope I've explained it. I hope I've explained why you do it. If you're working with me and I'm your attorney, I will, of course, walk you through this and we'll work on it. If you are a potential client or you're just wondering, you can always give me a call. And I can give you more specific legal advice if you are my client. But this has just been a general overview, and I hope it's been helpful. Thanks, and see you next time.